Hello, everyone. Welcome to Court with Krissy. I've got an update on Traverse City's first and friendly SovCit. Does the bond hearing go Mr. Bay's way? Watch and find out. I hope you like it. Court with Krissy is now in session.
Good afternoon. Are you Mr. Ophiuchus Bay?
Granted to the court, I am Fucus Bay.
Can you repeat that? I didn't quite catch it.
Granted to the court, I am Fucus Bay.
Ophiuchus Bay. Okay.
Yes, sir. I can't see.
You can't see your attorney?
No.
Something funny is going on Zoom. Oh,
No.
see, it's Mr. Atwood down.
That's because I put the spotlight on him at one point.
Oh.
So I'll
Hi, Mr. Atwood.
let's see.
Yeah, I see
I'll
Mr. Atwood
replace-
there.
Let's see, we'll spotlight the defendant
There it is.
instead. So that is file 2082 of 2024. Mr. Graff is here on behalf of the defendant, Mr. Atwood, for the people. And this is the date set for a preliminary examination. Mr. Graff, what does your client wish to do?
Excuse me, Your Honor, we'll be waiving today. We'd also like to ask about bond.
Okay, so Mr. Atwood, any objection to the waiver?
No, Your Honor.
And Mr. Ophiuchus Bay, has Mr. Graff discussed with you the purpose of today's hearing, and is it your own decision to waive that hearing?
Yes, Your Honor.
No one's used any force or threats or made any promises to you to get you to waive that right, have they?
No, Your Honor.
All right, then let's take up the bond matter before I sign the bind over. Mr. Graff.
Thank you, Your Honor. Your Honor, I represent my client in this case as well as a circuit court probation violation. Previously, he was being held on the felony probation violation with no bond. That was recently amended to a $25,000 10% back on or about May 20th. And that matter is essentially being put on hold or punted down the road until resolution of this case. To my understanding, the original bond in this matter was set at $75,000 cash or surety. My client is indigent. And so 75,000 essentially no bond at all. I would ask the court to consider a reduction in the bond. Obviously, he's got to post bond in 2 cases. He's got to comply with the terms in this case as well as felony probation. And so it would be a pretty strict regimen. I think my client understands if he doesn't comply with the terms in both cases, he can make a very bad situation very much worse. I would ask the court to consider not only a reduction in the bond amount, but also in order to, I guess, quell any concerns of the court or the people that he may or may not return, to be inclined to wear GPS tether if that was a term the court would be imposing. But again, I think he's got a lot on his plate. I think he understands the ramifications of failure to comply moving forward. But again, my biggest concern is 75,000, essentially no bond at all.
Well, you said he's indigent, so
Correct.
$1,000 would be no bond at all, right?
That's
So
a number
you're
that somebody can-
asking for a PR bond.
I'm not. I understand because the other case is a 25,000 10%. But what I'm indicating is $1,000. At least there's something there to reach for. 75,000. That's more than many people who are fully employed making an entire year. And so that's not even something that most people can fathom on their own, especially if someone's indigent. And so if the court would be inclined to give some type of number, maybe 10% or otherwise, that's at least a figure somebody can wrap their head around. If there are arrangements, they could be made, but it's something as opposed to essentially no bond at all.
Okay, let's hear from the prosecutor then. Mr. Atwood, response?
Thank you, Your Honor. I think the amount that was originally set is appropriate. The defendant has a long history. He's a habitual offender fourth on this particular charge. And again, as Mr. Graff indicated, he was on felony probation at the time. Additionally, when this call came in, the report was originally that the defendant was selling methamphetamine and fentanyl in the, I believe, the Bay Hill area. They found both of those substances on him in a a bag that also contained the business card for his felony probation officer. There's enough of a concern here, obviously, that he was engaged in actions beyond possessing these substances, but alone possessing these things, he was committing allegedly a high severity felony while on felony probation. I think that alone with his record would justify the bond amount. Thank you, Judge.
And the circuit court probation, that is for a similar charge.
Similar involved controlled substances, but the actual charge and conviction was bringing drugs into the jail. I believe in that case, I could be mistaken. I believe it was fentanyl in that case.
Okay, so the reasons for the high bond in this case in cash was that the defendant is currently on felony probation. He was unemployed at the time the report was prepared, has a history of drug abuse, and less than a year at his current residence, and a history of failure to appear, meaning 2 or more. There was a rather high praxis score of 7, and release on recognizance was not recommended. The request is for a lower bond, but I think an appropriate bond might be 25,000 cash or surety. So that's the best I can do, Mr. Graff.
Thank you.
All right, then. And I would note that these are the types of cases, methamphetamine, where people just don't show up a lot of times. And I'm given the history of failure to appears in the past, I'm concerned that we might not see the defendant if he isn't posting a substantial bond. So let's go to the waiver then. And the examination has been waived. The defendant is bound over to the circuit court to appear next on June 13th at 8 a.m. for the purposes of a circuit court pretrial conference, that is on the charges in the complaint. Bond is reduced to 25,000 cash surety with same conditions. Arraignment, Mr. Graff.
Thank you, Your Honor. We waive a form of reading the information. My client understands the nature of the charges, associated penalties. He also understands his rights. He asks court to deny not guilty plea and continue to matter for pretrial on the 13th of June.
I will enter a not guilty plea on your behalf, Mr. Fucus Bay, and if there's nothing else, we're all set for this morning. Good luck to you.
If I may, before my time, Board, do I have your permission to sign this notice? I'll send you a copy. Mr. Fuchs Bay?
What was that?
There's a form here for the signature line for each of us. Acknowledge the notice of the next hearing. Do I have your permission to sign your name to this form?
Indeed, as long as after you sign it, could you sign a subrogate beneficiary, please? Thank you.
What do you want me to write?
Subrogate, SUBROGEE,
Okay.
beneficiary,
Beneficiary. Okay.
by,
Done.
yes.
All right.
Thank you.
Thank you.
Thank you.
All right, thank you.
Okay, I think we're all set.